May I request Justice Sardar Tariq Masood Sahab to apprise us of his ideas and thoughts.
अशर साहब, अल्लाह आपको सेहत दे। आपकी मेहरबानी कि आप हमारे साथ हैं इस कंडीशन में भी। और मैं वेलकम करता हूं जनाब सजाद शाह साहब को कि वो हमारे मेंबर जुडिशल कमीशन के मेंबर बने। और मैं ये भी कहता हूं कि ना सिर्फ ये बहुत ही लकी हैं, बल्कि इनको प्रिविलेज मिला है कि अपने ही सक्सेसर को ये खुद ही अपॉइंट करके जाएं, which he did. Now, the recommendation which were given to us, these are, first of all, these are contradictory. On one hand, it was said that there would be a seniority plus competence, and for that purpose, from each high court, 3, 4 or 5, 6 judges will be judged. But we have seen that on the principle of seniority, the Chief Justice of Peshawar Court was nominated for appointment as a judge of Supreme Court. No data whatsoever for the other judges have been provided to us to make a comparative analysis. Presently, there are 4 vacancies for appointment as judge of the Supreme Court, and according to Article 175(8) of the Constitution of the Islamic Republic of Pakistan, the Commission by majority of the total member can nominate one person for each vacancy to the Parliamentary Committee for appointment as judge of the Supreme Court. So the Constitution is not giving any mandate to this Commission for appointment of a judge of the Supreme Court for anticipated vacancies, which is being done now. Although in Rule 3.1 of the Commission, word anticipated is mentioned, was introduced, but the rules cannot overrule the article of the Constitution, which otherwise is quite clear, having no ambiguity. The letter dated 20th July 2022 is silent as to who amongst the judges of the High Court of Sindh has been proposed for anticipated vacancies. If this principle is to be followed, then of course we all and the other judges of the Supreme Court may be allowed to propose their successor, and they also be nominated and approved for appointment as anticipated judges of the Supreme Court. मेरी ख्वाहिश तो कम से कम ये है, बाकियों के बारे में कुछ नहीं कह सकता. Even otherwise, if we approve all the nominees judges, then of course number of the judges in the Supreme Court will be 18, which is against the Constitution. Although under Section 177 of the Constitution, the eligibility for appointment of a judge as a judge of the Supreme Court is 5-year service as judge of the High Court. But practice and propriety always demand that seniority principle shall be considered first, and in case of appointment of a junior judge, while ignoring the senior, and that too without assigning any valid reason. I will valid पे मैं जोर दे रहा हूँ जी. Eyebrow may be raised regarding their working in the relevant high courts. It was decided in the previous meeting of the Judicial Commission that there should be. Sorry, ऐसे वो आ रही है. उसके ऊपर वो नेक्स्ट आ रही है, वो मुझे समझ ही नहीं आ रहा. अच्छा. That there should be criteria for appointment of the judges in the High Court and the Supreme Court, and for the said purpose a committee was constituted to suggest suitable amendments in the relevant rules and propose a criteria for appointment of judges to the Supreme Court. However, unfortunately, neither the criteria nor the amended rules have been framed by the said committee till date. Although the Honorable Chief Justice has stated on previous meeting that integrity, capacity, temperament, and one thing more, competence, have been settled in that meeting. But even then, that has not been converted into the rules, and the matter was deferred for further deliberation to judge the how the criteria will be determined. The list provided of the nominee judges, barring Chief Justice of the Peshawar High Court, who are the junior judges than their senior, and their senior judges are more eligible. So far, I have gone through the data for appointment as judges of the Supreme Court than the junior nominees. The letter written by Mr. Justice Ahmad Ali Sheikh indicates that he had earlier wrote a letter on 12th March 2022, which was not shared with us in this meeting, in which he had written that due to some circumstances, he is not interested for elevation as judge of the Supreme Court. He is nobody to refuse so. This letter may not be a reason for not considering him for appointment as judge of the Supreme Court. If he was appointed as a judge of the Supreme Court and he refused, then Article 206(2) of the Constitution will operate against him and he will be deemed to have been retired. Only then the next judge, junior to him, can be considered for appointment as judge of the Supreme Court. Even otherwise, in the Constitution, there is no provision or concept for getting consent or refusal from a judge, Chief Justice, for appointment as a judge of the Supreme Court. On the other hand, Justice Atar Minallah, who is second to Justice Ahmad Ali Sheikh in seniority amongst Chief Justices of the High Court of the country, has been superseded and completely ignored. No data or record regarding his work and capacity has been provided to the Commission. There is no reason available on record as to why he has been superseded. His integrity, capacity, temperament, etc. is above board, which is known to everyone. His judgments are being considered, discussed, and relied upon by the judiciary of other countries. Nobody can raise a finger toward his integrity, capacity, etc. But surprisingly, he was ignored despite the fact that he is the most senior judge amongst the Chief Justice of the High Court. हमारी एक इनफॉर्मल सी मीटिंग पहले हुई, उसमें चीफ साहब का कहना ये था कि इस्लामाबाद हाई कोर्ट का जज का यहाँ लाने का कोई कंसेप्ट है ही नहीं. 175 में इस्लामाबाद हाई कोर्ट का जिक्र है. 175 में इस्लामाबाद हाई कोर्ट में जजेस बनाने का भी जिक्र है. 175 में ये लिखा गया है कि जजेस को जब सुप्रीम कोर्ट लाया जाएगा वो फ्रॉम दी हाई कोर्ट से लाया जाएगा. वहां किसी का नाम नहीं लिखा होगा, पंजाब से लाया जाएगा, सिंध से लाया जाएगा, कोयटा से लाया जाएगा, वो लाया जाएगा. So the high courts, there are 5 high courts. And we have an example. Iqbal Umeedur Rahman was appointed as judge of the Supreme Court from Islamabad High Court. So, his ignorance, उसको ignore करना, This is, I say, he is the most senior Chief Justice of all the High Courts. But he has been ignored at all. And there is no reason for that. It is quite clear that in the High Court of the Sindh and the Lahore High Court, and amongst the Chief Justices of all the High Courts, there are many senior judges than the nominees for appointment as the judge of the Supreme Court. This amounts to discrimination, which is against the mandate of the Constitution. We daily decided the cases in the courts on the basis of the discrimination. But why a discrimination is being done in our own institution? On the other hand, the propriety demands that the seniority must be considered first. If anyone is found not capable, despite being senior, for appointment as judge of the Supreme Court, valid reason, I just say again and again, valid reason. ये नहीं कि किसी की 4 जजमेंट फालतू हो गई हैं तो वो अब उसकी वैलिड रीजन बन गई, या कोई जेंटलमैन है तो वो वैलिड रीजन बन गई. बात ये होगी कि किसने क्या काम किया और किस किस्म का काम किया. For not appointing said senior judge shall be given. This would mean that the senior should not be considered for appointment in the Supreme Court, but the Honorable CJP's letter dated 20th July 2022 reveals in para 9 and specifically mentioned that those judges who have been ignored now can be appointed as judge of the Supreme Court in future. If they are eligible for appointment as a judge of the Supreme Court in future, then why presently they are not nominated for appointment as judge of the Supreme Court? कल अगर वो बन सकता है जनाब चीफ जज ऑफ द सुप्रीम कोर्ट, तो आज क्यों नहीं बन सकता? या तो उसका रास्ता बंद कर दें, कह दें हमेशा में करियर डी बार हो गया, बात तो खत्म, क्योंकि है ही कॉम्पिटेंट नहीं है, उसकी इंटेग्रिटी खतरनाक है, तो बंद कर दे इसकी उसका रास्ता. लेकिन वंस यू से कि ये कल आ सकता है और फिर वो नहीं आ सकता, ठीक है जी. If they are eligible for appointment as judge of the Supreme Court, वो मैंने अभी पढ़ दी, the data provided and the queries made from the different corner of the bar association indicate that the senior judges who have been ignored are more competent to become judges of the Supreme Court than the nominees. The violation of the seniority and competence will not only hurt their feeling, and if for the sake of argument, as mentioned para number 9 of the above said letter, in future they are appointed as judge of the Supreme Court, the said senior judges in the High Court will become junior to the nominees in the Supreme Court. And this is, I don't know, इसको कैसे हम अज़म कर सकते हैं? We should not manipulate the system by making those who are juniors by them and then making them seniors in the Supreme Court. The Bar Council and Bar Association, who always stand for the judiciary against an unconstitutional act in our country, always done by the forces, have also very serious reservation regarding the appointment of the judges against the principle of seniority. And such reservation are the result of collective wisdom of legal fraternity. And the same cannot be lightly ignored. To abide by seniority principle has been their consistent stand for about a decade. हमेशा से उनका यही स्टैंड रहा है और वो यही कहते रहे. Sorry, sir. So far, nominees from the High Court of Sindh are concerned, no data of Mr. Justice Ahmad Ali Sheikh is provided, and data provided regarding the nominees, along with the 2 senior, indicate that Mr. Justice Irfan Sadat Khan authored 169 detailed judgment and 28 short judgment out of 197 reported judgment. ये जो डाटा फ्राहम किया गया पतली कॉपी में, मैं वहां से पढ़ रहा हूं सर, आप भी सामने रखना कि देखना चाहिए, देख मैं वहीं से करूँ. Indicating that his detailed judgments were 86%, whereas Mr. Justice Aqil Ahmed Abbasi authored 166 detailed judgment and 96 short judgment out of 262 reported judgment, indicating that his detailed judgments were 64%. Whereas Mr. Justice Sayyid Hassan Azhar Rizvi authored 70 detailed judgment and 65 short judgment. He relied more short judgments out of 135 reported judgment, indicating that his detailed judgments were 52%. Mr. Justice Nadeem Akhtar authored 152 detailed judgment and 63 short judgment out of 215 reported judgment, indicating that his detailed judgments were 71%. Mr. Justice Muhammad Shafi Siddiqui authored 106. This is what I'm saying again, because it was said that Mr. Gheba and Mr. Amir Bhatti, who is the Chief Justice, he had given very few detailed judgment, reported judgment. मैं इसलिए इसको थोड़ा सा कहा है. 71%. Mr. Justice Muhammad Shafi authored 106 detailed judgment and 42 short judgment out of 148 reported judgment, indicating that his detailed judgment was 72%. Likewise, Mr. Justice Niamatullah Phulpoto authored 134 detailed judgment and 111 short judgments. We all know in फौजदारी केस कैसे शॉर्ट जजमेंट लिखी जाती हैं, किस तरह लायर्स को कहा जाता है विड्रॉ करो, क्या करो, you know everything, we know everything. Out of 245 reported judgment, indicated that his detailed judgment were 55%. This equation also points out that the ignored judges have given more detailed judgment than some of the nominees. Rather, Mr. Justice Irfan Sadat Khan has authored 86% detailed reported judgment, which are highest than the judgment of the nominees. सबसे ज़्यादा है इसकी. But he has been ignored. He is not competent. उसकी कैपेसिटी नहीं है लिखने की. इसलिए even the reported judgment of Mr. Justice Irfan Sadat Khan and Mr. Justice Aqil Abbasi are more than the reported judgment authored by Mr. Justice Sayyid Hassan Azhar Rizvi and Mr. Justice Muhammad Shafi Siddiqui of the High Court of Sindh. Now, the data so collected from the computer bench of the Supreme Court indicate that 4.8% judgment authored by Mr. Justice Irfan Sadat Khan were set aside, whereas his 57.6% judgments were upheld. 3.5 judgments authored by Mr. Justice Aqil Abbasi were set aside, whereas his 44% judgments were upheld by this court. 5% judgment handed down by Mr. Justice Sayyid Hassan Azhar Rizvi were set aside, whereas his 56 judgments were upheld by this court. 4.9% judgment authored by Mr. Justice Muhammad Shafi Siddiqui were set aside, whereas his 60% judgment were upheld by this court. Likewise, 11.7 judgment authored by Mr. Justice Niamatullah Khan Phulpoto was set aside. सबसे ज़्यादा इसकी जो set aside हुई. Whereas his 48 judgments were upheld by this court. The above data and percentage of set aside judgment authored by Mr. Justice Irfan Sadat Khan and Mr. Justice Aqil Ahmed Abbasi are lesser in number than the other nominees, judges of the High Court of the Sindh, which indicate the better competency and command of law of the said two senior judges. The reported judgment of Mr. Shahid Wahid of the, अब लाहौर आउट की बात कर रहा हूँ, वहाँ तो मैं खत्म कर दिया. The reported judgment of Mr. Shahid Wahid of the Lahore High Court are less than the judgment authored by Mr. Justice Shujaat Ali Khan. The detailed reported judgment of Mr. Justice Shahzad Ahmad Khan Geba, Shahzad Ahmad Khan and Shujaat Ali Khan are higher than the judgment of Mr. Shahid Wahid and almost equal to Mr. Justice Muhammad Amir Bhatti. So this comparative chart annexed with the record also indicate that senior judges are more eligible than the nominees judges. 2.6% judgment authored by Mr. Justice Amir Bhatti were set aside, whereas his 76.5% judgments were upheld by this court. 18.2 judgment authored by Mr. Justice Malik Shahzad Ahmad Khan. Sorry, sir. Ek minute. Bismillah. %% judgment authored by Mr. Amir Bhatti was set aside, whereas 2.6 was there. 18.2 judgment authored by Mr. Malik Shahzad Ahmad Khan was set aside, whereas his 60.4 judgments were upheld by this court. 2.3% judgment authored by Mr. Justice Shujaat Ali Khan were set aside, and whereas his 71% judgment were upheld by this court. On the other hand, 4% judgment were authored by Mr. Justice Shahid Wahid were set aside by this court, whereas his 77.8% judgment were upheld. So the percentage of set-aside judgment of Mr. Justice Amir Bhatti and Mr. Shujaat Ali Khan are lesser in number than the nominee judge Mr. Shahid Wahid of the Lahore High Court. This data also confirms that the senior most judges and other seniors are equally rather better competent than the nominees. So far, Ni'matullah Phulpoto is concerned, I totally agreed with my senior most judge, Usmani Saab. I have also gone through the judgments handed down by Mr. Justice Ni'matullah Phulpoto, who has normally authored his judgment on criminal side. 111 judgments were challenged before the court. Out of 9 were pending. Leave was granted in 27 cases, and 13 judgments were set aside, and his judgment set aside, whereas 53 cases were dismissed, out of which many of them were dismissed having become infectious. मुझे इसलिए मैं ये कह रहा हूँ, मेरे पास वो डाटा भी है, रिकॉर्ड मेरे पास मौजूद है, मैं कहेंगे मैं एक एक नंबर पढ़ के बताऊंगा, वो लिखा हुआ है कि those has been become infectious for the reason या तो बंदा जेल से छूट गया या वो मर गया. ज्यादातर उसकी तमाम वो जजमेंट जो हुई हैं, लॉ हुई हैं, या कहें कि उसको डिस्पोज ऑफ किया गया है, वो इस ग्राउंड पे डिस्पोज ऑफ हुई है. ये मेरे पास वो सारा रिकॉर्ड मौजूद है जो मैंने ऑफिस से मंगवाया. A perusal of the judgment indicates that although he is known to be a judge having command on criminal case matters, but rightly as said by Usmani Sahab, but his judgments are average, indicating that his concept toward criminal law is not clear. मैं सिर्फ एक एग्जाम्पल दूंगा. One example is that in all the cases, अभी अब कहें मैं सारे खोल के एक एक लफ्ज पे पढ़ के बता देता हूं, मैंने अंडरलाइन किए हुए. In all the cases, he firstly discussed the medical evidence and only observed that the death of the deceased was unnatural, hence it corroborates the ocular account. The Supreme Court has already settled as far back as 1990 and 1991, Usmani Sahab ko pata hoga, that medical evidence cannot be considered as a corroborative piece of evidence, as it neither pinpoints the accused nor names the assailant, and it only gives the detail of the injury, the condition of the dead body, the cause of the death, duration between injury and death, and between death and postmortem, etc., and can only be considered as a supportive evidence, but not as a corroborative piece of evidence. मेरे सामने वज़ीर कानून भी बैठे, फौजदारी करते रहे, और उस्मानी साहब ने भी यही कहा, लेकिन मैं आपको ये एक एग्जाम्पल बताइए. But almost in each judgment, the learned nominee judge has observed the same as a corroborative piece of evidence for conviction. There are many other things. मैं अगर वो आपको पढ़ के सुनाने की कोई बताना शुरू कर दूं तो आप परेशान हो जाएंगे. When he gave the facts, he gave the ocular account was produced as PW3 and PW4. What PW3 say 1111 सारा कर दिया. What PW4 say 1111 उसकी पूरी कहानी बयान कर दी. फिर उसके बाद बाकी गवान का जिक्र कर दिया, फिर बहस की जिक्र आ गई, फिर आ गई अपनी उनकी ऑब्जर्वेशन. जब अपनी ऑब्जर्वेशन आई तो उन्होंने कहना, पहले तो मेडिकल को उन्होंने खंगाला, फिर उसके बाद कहना शुरू कर दिया PW3 appeared as a eyewitness and he said 1111. वो तमाम स्टोरी जो पिछले चौथे सफ़े में वो कह चुके हैं वो सारी फिर रिप्रोड्यूस की. PW4 से फिर 1111 वो सारी फिर रिप्रोड्यूस कर दी, और आखिर में कह दिया कि क्योंकि ऑक्यूलर अकाउंट ने बड़ा ठीक ठाक बयान दे दिया है तो दिस इज सफिशिएंट फॉर कन्विक्शन. तो कहाँ है वो अप्रेजल एंड री अप्रेजल ऑफ एविडेंस का जो प्रिंसिपल बनाए गए दिस कोड के, वो किधर है? मुझे तो कहीं नजर नहीं आए इन जजमेंट्स में. ऑन द अदर हैंड इट वाज सेड, जब शहजाद खेबा साहब को कहा गया कि उसको नहीं बना रहे हम लोग, अभी इसमें जो रीजन दिए वो यही दिया जी, उसकी एवरेज जजमेंट है. खोल के देख लीजिए, एक एक जजमेंट को पढ़ के देखेंगे, यू विल सी. ये मैं ये नहीं कहता कि वो लाहौर के जजेस का ये एक बहुत माशाल्लाह अच्छी बात है कि वो ईच एंड एवरी पीस ऑफ एविडेंस को डिस्कस करते हैं. रीअप्रेजल का एविडेंस का यही तो मतलब है. हम सुप्रीम कोर्ट में तो ये कह सकते हैं कि नो बस ठीक है, इट्स ऑलराइट, बोथ द कोर्ट्स हैव सीन एंड वी आर नॉट गोइंग टू से. हमारा तो और बात है, लेकिन जब अप्रेजल करना है ट्रायल कोर्ट ने, रीअप्रेजल करना है. रीअप्रेजल मीन द होल रीअप्रेजल, नॉट ए समरीली करना है. तो ये ऑलमोस्ट इन दी जजमेंट यही कुछ कहा है उन्होंने जी. हिज रीजनिंग अगेंस्ट द सेटल्ड प्रिंसिपल ऑफ अप्रेजल एंड रीअप्रेजल ऑफ द एविडेंस. What is even more worrying is that he adamantly refuses to read or follow our 30-year-old Supreme Court precedents, thus contravenes Article 189 of the Constitution. But he has been nominated. Okay. The information so far I have gathered from different corners of Sindh is that his integrity is also questionable. Whereas the reason for his appointment given in the letter dated 20th July 2022 is silent regarding his integrity. Same is the position in regard of Mr. Justice Muhammad Shafi Siddiqui. The information so gathered from the liars in the relevant quarters from Sindh is also found questionable integrity, and the reason for the appointment are also silent regarding his good integrity. The information also reveals that both are accessible. उन्होंने वो भी बताया कि accessible किन के जिम्मे है, किन के अंडर है, लेकिन मैं वो वहाँ जिक्र नहीं करना चाहता. But they are accessible according to the bar and the people जिनसे मैंने को कंसिडर किया. बिकॉज हमें तो एक इन्होंने तो कह दिया कि ये हैं, ये बंदे ठीक है. अब हमारे पास तो और कोई सोर्सेज नहीं है, हमने तो वहीं से जाके पता करना है सिंध से, और सिंध में जो इक्का दुक्का जो हमारे जानने वाले हैं उन्हीं से पूछा जा सकता है जो थे. The integrity along with seniority is the prime consideration for appointment as judge of the Supreme Court. But reasoning given the head of the each nominee judge is silent regarding their integrity. It is also a circumstance that nobody has raised his finger toward the integrity of Mr. Justice Irfan Sadat and Khan and Aqil Ahmed Abbasi. यहाँ भी आप लोगों ने जिन लोगों ने कहा है उन्होंने कम उनकी इंटेग्रिटी के बारे में किसी ने कोई बात नहीं की. So for temperament of Mr. Justice Aqil Ahmed Abbasi is concerned, the same is not supported from any corner of the legal fraternity And this fact by itself is not sufficient to debar such a nice judge who work appreciably and being respected in legal fraternity due to his integrity and competency. सर टेम्परामेंट, खाली टेम्परामेंट की वजह से किसी जज को डिबार कर देना, तो ये तो मैं समझता हूं अगर हम अपना यहाँ सुप्रीम कोर्ट में अगर हम देखें तो कई दफा हमारे जजेस टेम्परामेंट लूज कर जाते हैं वकला की नालायकियों के ऊपर, वकला की किसी बात के ऊपर कर जाते, लेकिन इस वजह से उसको निकाल दें, उसको नॉमिनेट ना करें, सिर्फ इस वजह से। अदरवाइज ही एवरीथिंग वाज इक्वल, वो कॉम्पिटेंट भी है, वो सीनियर भी है, सब कुछ है, लेकिन नहीं। सर मैं दो बातों का जवाब दे दूं, फिर मैं आखिर में वो बताऊंगा कि मैं किन को कर रहा हूं, किन को नहीं कर रहा। देखिए सर, आपने कहा कि वो कैसर रशीद वाला बात मैंने पहले ही कह दी, आपने उसका कंपैरेटिव डाटा हमें नहीं दिया कि हम उससे किसी तरीके से वो कर सकें। अमीर भट्टी के बारे में कहते हैं ही इज़ ए गुड जज, और मेरे भाई ने ये कहा कि हमें हार्ड कोर सिविल का बंदा चाहिए। अमीर भट्टी वर्क इन मुल्तान डिस्ट्रिक्ट जुडिशरी डिस्ट्रिक्ट कोर्ट्स फॉर डिकेड्स, उसका हार्ड कोर का इतना तजर्बा है सिविल साइड पे, रेवेन्यू साइड पे, हर साइड पे, he could be a good addition in this institution for that purpose. और क्रिमिनल के लिए फुलपोटो को लाने की जरूरत बजाय आप ये देखें कि यहाँ क्रिमिनल के केसेस कितने थोड़े से ही हैं, इतने ज्यादा नहीं हैं। यहाँ सिविल केसेस जो हैं वो मल्टीपल थाउजेंड एंड थाउजेंड में है। असल केसेस तो वो हैं जिनको खत्म करना है, जिनके लिए मैक्सिमम जजेस यहाँ पे सिविल के पहले ही अवेलेबल है। फौजदारी के तो इक्का दुक्का है बकौल इजाजुल हसन साहब के। तो इसलिए मैं ये समझता हूं कि ही इज द मोस्ट कॉम्पिटेंट एंड सूटेबल पर्सन। नाउ आई कंक्लूड करता हूं जी। आई विद ऑल रिजर्वेशन, मेरी रिजर्वेशन हमेशा ये रही है जी सीनियरिटी की। ये सीनियरिटी प्रिंसिपल को जब भी हम वायलेट करते हैं इस मुल्क के लिए कुछ अच्छा नहीं होता। I with all above reservation is not inclined to approve the proposal for appointment of Mr. Justice Sayyid Hassan Azhar Rizvi, Muhammad Shafi Siddiqui, Niamatullah Phulpoto, falling at serial number 4, 6 and 7 of the seniority list respectively in the High Court of the Sindh, and Mr. Justice Shahid Waheed falling at serial number 4 of the seniority list in the Lahore High Court. As we have been provided comparative record, and I say that from the above comparative discussion, I am confident that in view of the seniority principle, integrity and competency, Mr. Justice Muhammad Amir Bhatti is suitable for appointment as Judge of the Supreme Court on vacant seat. Likewise, on the principle of seniority, Mr. Justice Ahmad Ali Sheikh, keeping in view his vast experience as a Chief Justice of the High Court of Sindh and his earlier consideration for appointment as an ad hoc Judge of the Supreme Court, he is also suitable for his elevation as a Judge of the Supreme Court of Pakistan. If he is proceeded under Article 206, then of course Mr. Justice Irfan Sadat Khan and Aqil Ahmad Abbasi are the most suitable judges to be appointed as a judge in Supreme Court of Pakistan, and I approve their name as such. So far, Mr. Justice Kaisar Rashid Khan is concerned, although he is a senior most judge of this Peshawar High Court, but surprisingly, no comparative data qua other two judges has been provided so that a comparison could be made regarding their competency, integrity, besides seniority. So in my humble view, his matter may be deferred. Thank you very much, sir, Chairman साहब. मैंने कुछ टाइम ज़्यादा ले लिया. I am sorry.
Thank you very much, Justice Tariq Masood Saab. Your analysis is very illuminating, and all that you have said needs to be dealt with during our discussion and will be answered.